You want to go ahead and do tackle 236? We have some members that are going to be in
we
there.
do that. 236. Thank you. All right.
And I am, members, we are going to bring in lunch, so just be mindful. We do still have a lot of bills. So,
Thank you. 236. This is a colorful bill. This is brought on behalf of the Louisiana Humane Society. We are seeking to improve and modernize and clarify the law on bestiality in the state of Louisiana. I believe there is a very lengthy amendment the committee has. I'd like to take the bill's correct posture, please.
okay. If Ms. Fogelman wants to read the amendment.
Okay, Mr. Chairman and members, the set of amendments is number 3269 and is being offered by Representative Stefanski. On page 1, after line 17, we're adding language which says, nothing in the act which originated as Senate Bill number 236 of the 2018 regular session of the legislature shall be construed to alleviate any person convicted or adjudicated delinquent of a crime against nature from any requirement, obligation, or consequence imposed by law resulting from that conviction or adjudication, including but not limited to any requirements regarding sex offender registration and notification, parental rights, probation, parole, sentencing, or any other requirement, obligation, or consequence imposed by law resulting from that conviction. On page 2, between lines 14 and 15, adding as an element of the offense, filming, distributing, or possessing pornographic images of a person and an animal engaged in any of the activities described in paragraphs 1 through 6 of the same subsection. Removing the application of on page 3, line 10, removing the application of enhanced penalties for activity that results in the serious bodily injury or death of the animal. On page 3, line 17, removes the 1-year minimum sentence and the enhanced penalty provision. And then on page 3, between lines 27 and 28, adding language which states that if a person convicted of the offense of sexual abuse of an animal is released on parole, the Committee on Parole shall require the person, as a condition of their parole, to participate in a sex offender program as defined by present law. And then finally, on page 4, between lines 10 and 11, it adds a second or subsequent conviction of RS 1489.3 to the definition of sex offense, which would require persons convicted of a second or subsequent conviction of that offense to register as a sex offender.
Okay.
And I can speak to those amendments if you'd like, Mr. Chairman.
Let's go ahead. Representative Stefanski has offered the amendment. Is there any opposition? The amendment puts the bill in the posture the author would like to present it. Would there be no opposition? The amendment's adopted.
Thank you, Mr. Chairman.
Why don't you go ahead and talk about the bill?
Yeah, I had the opportunity to work with a lot of House and senators after the bill passed the floor of the Senate. There were a lot of concerns regarding the bill's posture, how the punishments related to rape of people and the like. So what we sought to do was to work to make the bill still a very effective bill to fight the bestiality problem in Louisiana, but also to try and address a lot of those concerns. I want to thank Senator Brett Alwan and Mr. Stefanski in particular, who are working with me to make sure this bill could be put in a posture where people will be more comfortable knowing that we're addressing the problem, but we're not trying to make it on the same level as some of the other crimes that are already on the books that deal with actual human beings. So I want to thank them for all their hard work. Ladies and gentlemen, this bill, our current bestiality law is basically a sentence in statute. It is non-specific, it is very general, and it has potentially some constitutional implications because of its location in statute. What we're seeking to do right now is the Humane Society has been very involved across the state in trying to combat this horrendous practice. And in consultation with district attorneys and other law enforcement, they were made aware of the fact that the law is very archaic. It does not address any of the current modern technology. It doesn't address video voyeurism, doesn't address soliciting animals for sex on the internet, which is a thing, and a variety of other issues. So what we seek to do is to take bestiality out of its current problematic section of the law, give it its own best practices section of clear, concise statute that allow law enforcement to prosecute individuals who do this under the fullest extent of the law. Many states are doing the same thing we're doing. They're going through their bestiality statutes and doing tremendous updates. I will not go into There are states that have very specific, colorful examples as to why they had to update their bestiality law. I'm not going to do that today. I'm going to spare you that. If you want to see it, you can look at the Senate debate on it. But for those of you who don't think this is a problem, I will give a couple of general examples. In St. Tammany Parish, you had an individual who had over 2,000 images of child pornography depicting acts of sexual violence, bondage, and bestiality involving children. DeSoto Parish, you had a man who was originally arrested for playing a cell phone in a woman's bathroom, and when the officers went to investigate him, found videos of him having sex with his dog. I will leave the rest here. But the point is that this is a very serious problem. It's a very serious offense. And it's very important for us to make the law clear and concise on this because, as many of you know who have a law enforcement background, like Mr. Bacala, for example, individuals who are frequently convicted of bestiality or individuals who commit child molestation, there is a direct correlation. So people who begin with animals usually graduate to something else, and the sooner that law enforcement can come in, intervene, and put these people away and help them get help. Another huge component of the amendment Mr. Stefanski has put on is that we put a greater emphasis on getting these people mental health and mental health services. So that's what the bill does. I have Ms. Julia Burrow-Melanson with the Humane Society to answer any questions that you might have regarding the bill.
I'm sorry. Representative Hodges, question?
Thank you, Mr. Chairman. Thank you, Senator Morrell. I do have a couple of questions and a couple of concerns I hope that y'all can clarify to me. We already have the law on the books, as you know, and I got staff to check. 15 people have been prosecuted recently as last year for bestiality. And so I guess I'm asking why are we making a whole new law?
Well, I think there is no question that people can be prosecuted under the current law. There is a concern that other people, if in conversations with law enforcement, in order to fill the loopholes the law doesn't cover, they try very diligently to try and use the loopholes that exist in the current bestiality law to prosecute people under animal cruelty. There's significant challenges there because unless the animal is actually damaged, you really don't beat the threshold in the animal cruelty statute. So I would challenge, yes, there are 15 people that were charged. There could have been 150 people that should have been charged.
Do you know if there were cases that couldn't be charged? Look, I applaud what you're doing. It is the most sickening, disgusting thing. We don't even want to talk about it.
Ms. Burrow can answer that.
Okay.
There was a case recently where the individual that was assisting the woman in having sex with the dogs and filming it was not able to be charged because he physically wasn't having sex with the dogs. He was just assisting the woman to have sex.
Which would not fall under the current
which
bestiality
does not fall under the current statute or animal cruelty.
Okay, so have any other states adopted this yet?
There have been 5 states that have adopted the same language as this in the past year. Texas was most recent.
Okay. Okay, I have a specific question online on page 3. We could just talk about this. Is something that concerns me. I talked to Representative Stefanski about it. Hopefully we can fix this because I think it could be problematic. Well, on page 2, line 16, it says animal means non-human, dead or alive. So if you take that in the new statute that you're proposing and we put it, and then you look at on page 3, it says shall not harbor, own, or possess or exercise control over any animal and not reside in any household where an animal is present, engage in an occupation, whether paid or unpaid. And now here's where my concern comes in. What about a person, if they're charged and they go to jail, we can't send them to a prison where there's animals, where there's livestock, and there are presently jails that do have farm animals. So we can't go there. There are no vegan jails. So, that's a concern that I have. And then there's the employment issue.
Okay, can we go through?
Sure.
Well,
okay.
If you look at it, the way the law is defined, it specifically says a household or a job and prison is neither a household nor a job.
Okay,
So
well-
I think for that first point, I think the way it's currently defined.
Well, that's a point, that's aside from
Okay.
the other two issues.
Okay.
That's an issue that's not addressed in here. But the constitutional issues that I fear might be in here is the employment restrictions and the housing restriction. If after they get out of prison, if we have a vegan prison we're gonna send them to, because what about a chicken? A chicken is a dead animal. So I don't know how we're gonna fix this. They can't go back and live with their parents in their parents' house if they have a dog. Because it does say a dead animal, and
Okay.
so we can't find them.
Well, the dog example, you're 100% correct in that the person, if their family has a dog, but that being said, there are current, using that same example, a person who's convicted of child molestation and is not allowed to work or operate in a household with children of a certain age, if their parents are watching or custodians of their grandchild, that person can't go back to that household either, and that's been upheld repeatedly as being constitutional and as far as a dead animal that is for consumption is food that is no longer
Right,
defined
but it doesn't say that. It just says dead animal.
if that were the case, then if someone, what's that?
That only applies to this section. We're dead. We're talking
Yeah,
about where
it-
you're abusing the animal.
Why don't you?
Sorry, the way I was reading it is that it only applies to that section where you're only talking about abusing the animal. And so, and as gross as this is, people actually do have sex with dead animals for the purpose of
Right.
this.
So the reason why the statute says dead or alive is because if a person's having sex with a live animal or a dead animal, it's still bestiality.
We need to clarify.
As far as your other constitutional concern regarding someone having, fried chicken or something like that, that is no longer an animal. It is considered food by definition.
Valerie.
Hang on just a second.
Okay.
Okay. Well, okay, Senator Morrell, we need to clarify this. Staff agrees with me that it is very broad. And because it does say, if you look on page 2, it says for purposes of this section, and it includes that in there. And this is extremely gross. I wish we weren't not having this conversation, but
I
we
wish we
are.
weren't having it too.
But we do need to fix this.
If your point of clarification is that you want to give some greater tightening language regarding live and dead animal, I am not opposed in principle to that.
Well, it's not just that, but it's the residing, the occupation, the jail. What if it is challenged in court? And what if it is ruled unconstitutional? I know we've talked about this. We've had a couple of conversations about going in and striking in your bill, adding back in the strike that says with an animal. And I know we talked about, we said it kind
You're
of,
talking about retaining the bestiality language in the sodomy law.
just in case, even if we did it for a year to see if this would be upheld in court.
Okay. I don't believe in having two statutes on the books just in case. I think that's a very dangerous precedent.
Well, okay, but this is very broad, and I don't think it's going to be upheld in court. And then what are we going to have to prosecute people on?
This law is very similar to the law we use for child molestation, which has been upheld in the courts over and over again. There are plenty of people who, when states started passing child molestation law, restricting people's vocations, saying you cannot interact with children, people brought those challenges saying, well, I'm someone that works in daycares. I should be back in a daycare. And the court said, no, as a condition in the law, since you were convicted of doing this heinous act, you don't get to work in daycare. So if a person is convicted of bestiality and they want to go work at a poultry processing plant, I think the courts can say, sorry, you can't work at a poultry processing plant. Now also,
But they can't go to Walmart either. If they're
when an animal is packaged for food,
This 3-minute debate is up.
okay.
okay, can we say asked and answered, Mr. Chairman?
Asked and
There
answered.
you go. Asked and answered.
All right.
Thank you.
So how can we tighten that language?
If we want to talk about the saying that food is not included as part of dead animal, I am happy to work on that language with you.
And what about the person that gets out of jail that has no place to go because their parents has a
Then their
parakeet?
parents have to pick between the parakeet and their kid. That's
Okay.
that's what that means. Just like if the parents had a convicted child molester as a child, they were the guardians of a minor child. They would have to decide whether or not.
Asked and answered.
Okay. Well,
Do you have an amendment,
Yes, I
Representative Hodges? Okay, if she has an amendment, let's do this. Let's let Representative Marcel ask her question. Ms. Fogelman is back. Ms. Fogelman, can you? Let's let Ms. Fogelman and Ms. Hodges talk about her amendment. Representative Marcel for a question.
Thank you. First of all, let me thank you for bringing this bill. I'm sorry that we're having this conversation as well, Senator Morrell. A couple of things. One, I don't think anybody has made a motion to move this bill favorably, and so before I forget, I certainly want to do that. But secondly, I guess hearing the debate, I'm concerned that we're more concerned with where a person lives after they get out of jail when they've committed this heinous act with dogs or whatever type of animal it is, rather than children and people who have sex crimes. And everybody has to now register themselves as a sex offender. I don't think that that's currently in the law that's on the books now. Is that correct?
Correct.
This is a new criteria, registering as this type of offender. Is that correct?
Yes, ma'am.
That's not in the law currently if this bill doesn't pass, right?
Correct.
And I think we need to know people who commit these types of crime that are living by us if we have dogs or cats or whatever. Is that the general idea, same as with sex offenders?
Yes, ma'am.
Because you certainly don't want to be living next door to a sex offender if you don't know that they're next door and you have children that are running around, correct?
Yes, ma'am.
And so the idea is pretty much the same as the law that we put on the books for sex offenders. And in some instances, I think, although I understand the concept of why those laws were created, I think it makes it more difficult when people do get out if they don't get the treatment or whatever they need. For some of the lower line sex offenses, like carnal knowledge, when the person is 19 and the other person is 16, and they go to jail or they're on their suspended sentences or whatever it is, but they're still falling in that loophole and don't have places to go. And many times, they can't stay with their parents because their parents may live next to a daycare, across the street from a playground. So I'm just trying to figure out why are we having a conversation of where a person can live after they've committed these crimes. I don't see it as, I see it as apples and oranges because I think the offense with the people are certainly more appalling, but this is as appalling as well. I'd like to move this bill favorably, and we do this all the time where people have to find somewhere else to live. So I don't know where they're going to go, but I think the component in your bill for mental health is very, very important because people who do this certainly have a mental problem, and that's where we need to put our money. And as this legislation go forward this session and any special session, I would love to see us put money into the budget for mental health issues because people have problems, even the sexual problems altogether, whether it's children or rape or bestiality. They have mental health issues that we must address. Thank you for bringing the bill, and at the proper time, I'd like to move it favorably.
Thank you, Representative Marcel. Representative Hodges, is your amendment? You're right on.
yes.
Okay.
I believe it is. And just for the purposes of clarity, I just want to make sure that Senator Morrell will work with us. Kelly said she doesn't have time to do it right now on committee, but to tighten the lanes. But I believe you, Senator Morrell, that you want to make this as bulletproof as possible, that it's not struck down. And what I'm doing is simply to make sure that the statute stands until we have this bulletproof. And I think we can work on it to do that.
To be clear, I am more than willing to work with you on the proposed statute to tighten the language in regards to the
So that it's constitutional.
in regards to the with animal language in that debate. We'll continue to have that debate, but I want to be clear to the committee, I'm not agreeing to that. I'm agreeing
look,
to.
Okay.
the senator's going to keep
Thank
an
you.
open mind, and the representative's going to work with him. And
Right.
I misspoke you, but you do have an amendment that you do wish to offer. Right? Ms. Fogelman, explain the amendment.
Mr. Chairman and members, the set of amendments is number 3217 being offered by Representative Hodges. And what it does is restores present law with regard to RS 1489 by deleting from the bill on page 1 lines 8 through 17. And then would have to make technical changes to the title to conform.
Okay. Is there any questions on the amendment?
Can I speak on the amendment, Mr. Chairman?
Absolutely.
Okay. Essentially, this is the ongoing debate. There are some individuals that would like there to be dual bestiality laws on the books. The purpose of doing this bill is to create a concise, specific law dealing with bestiality. And though I appreciate Representative Hodges' concerns, I think this muddies the law tremendously, and it creates two separate statutes on what you can be charged. And that is not the goal. In other states that have done this update of the bestiality law, they have done the same thing that I'm doing, which is there is a single bestiality law in the books, and they delete the previous one. So, for example, strategically speaking, or procedurally speaking, if we create a new law dealing with a different act that replaces an old one, let's say a new armed robbery law, we don't keep the old armed robbery law on the book while we're testing the new armed robbery law. We replace it. And that's what we're doing with bestiality. There have been some concerns, and I'm sure you've seen all of the media on it regarding whether or not this bill does something that it doesn't do. The bill is about bestiality. The bill is about updating and modernizing the law, and this amendment undermines that. So I would ask you to please, I'm not in favor of this amendment.
Okay, Representative Hodges has offered the amendment. Do we have a quorum? Yes. Okay, we have a quorum. Representative Hodges has offered the amendment. Representative Morrell has objected to the amendment. A vote yes would be to add the amendment on. A vote no would be to not. Hang on just a minute. Give us a couple seconds. Okay, all right. Representative Hazel, a vote yes would be to vote the amendment on the bill. Representative Hodges' amendment, a vote no would be to not, and to leave the bill in its current posture. Ms. Spivey, would you take the roll?
Representative Bacala? Yes. Yes. Representative Bagneris? No. No. Representative Carpenter? Representative Cruz? Representative Duplessis? No. No. Representative Dwight? No. No. Representative Gaines? Representative Hazel? No. No. Representative Hodges?
Yes.
Yes. Representative Howard?
Yes.
Yes. Representative James? Representative Marcel? No. No. Representative Marino?
No.
No. Representative Muscarello? Representative Norton?
No.
No. Representative Pilot? Representative Stefanski?
Which one? This one, yes.
No.
No.
No amendment. No
amendment, no.
Thank you.
No, let me clarify. Representative Stefanski, let me clarify. There's an amendment by Representative Hodges that would delete basically the RS 1489 from the bill. A vote yes would be to accept the amendment. A vote no would be to not and leave the bill in the original posture. Okay.
Representative Stefanski? No. We have 3 yeas, 8 nays.
There are three yeas, 8 nays, and the amendment is not adopted. Representative, there are no more lights. Not yet. Let's yield the table to the opposition.
Absolutely.
Gene Mills, Family Forum. Dr. Will Hall, Louisiana Baptist Office of Public Policy. And Pastor Lewis Husser. Are you still here, sir? Also filling out cards in opposition who do not wish to speak is Dr. David Cranford, Louisiana Family Forum, and I. M. Fury of Bogalusa, Louisiana.
Mr. Chairman and members, forgive my voice. I'm under doctor's orders not to speak today, but I'm felt compelled to at least give you a perspective and caution you about something we're about to do.
And River Mills, we all know who you are, but just for the record, tell us who you are and who you are.
Gene Mills, Louisiana Family Forum.
Yes, sir.
Louisiana Family Forum is an organization committed to defending faith, family, and freedom in the state of Louisiana. Toward that end, we oppose the striking of Louisiana's bestiality clause, specifically page 1, line 11, 4 words, or with an animal. For the record, bestiality has been held punishable offense and prohibited scripturally for thousands of years. Make no mistake, nobody's supportive of that action or activity. This activity was first mentioned in the book of Exodus, and Christian doctrine has held it a heinous and punishable offense, in spite of recent media reports that assert that it's still legal in the state of Louisiana unless we pass Senate Bill 236. That's a mistaken misnomer. The legislature should not repeal the tried and true standard in favor of an untested theory. I agree with Representative Hodges. There are constitutionally vague and overly broad ideas, which, by the way, we do not object to. I submitted a red card, but it's not on the concept nor the intent that the author has stated that he seeks to accomplish by adding additional protections, but rather on the vagueness and the fact that one of our standards have been upheld, both within the court system and in the court of public opinion. This is an untested theory. I heard today in testimony 5 states have adopted this. According to our record, that's not the case. About 40% of the states refer to it as a crime against nature, about 40% refer to it as bestiality, and about 20% tested reveal some hodgepodge of the two. But to my knowledge, no one ever elevates the crime of sexual abuse against an animal over a criminal statute or a statute that we currently have on the books of a crime against nature. Louisiana's crime against nature statute, as it currently stands, those 4 words, that's the only dispute right here, members. 4 words, or with an animal. Striking it, moving it to a new area, or accepting a friendly amendment that accomplishes the intent of the author and preserves intact Louisiana's current anti-bestiality statute. Louisiana's crime against nature statute expresses a moral turpitude section of the law. That's a legal concept in Louisiana and in the United States that refers to acts of behavior that gravely violate the sensibilities and acceptable standards of a community. And it puts in the section a newly created under animal rights. Louisiana Family Forum opposes bestiality because it destroys a human soul. And we think that it communicates something that's significant by where it's currently located. Senator Morrell's expansion of these protections, which we do not object to, though we think they are vague and somewhat constitutionally broad, do not require the removal of those 4 words. It is not our intent to gut this bill, and the author may protest, but I would respectfully submit to you that the courts have upheld in Louisiana's 5th Circuit Court of Appeal that the court upholds and affirms the constitutional portions of Louisiana Revised Statute 489A1. We conclude that 2 types of behavior are severable, and a prohibition against human-on-human portion of the law can be removed or accommodated without affecting the validity or the intent of the human-on-animal prohibition. You don't have to strike this code in order to accomplish the author's intent. It's very simple. You go with what's tried and tested through decades and millennia, or you try something brand new. I'd like to know what those 5 states are, what their revised statutes concern actually accomplish, and whether we really do create a criminal offense against sexual abuse of an animal. I think the crimes against nature law, if you would retain those 4 words, there'd be no dispute. We'd remove our red card. Thank you.
Thank you, Reverend Mills. Dr. Hall?
I'm Will Hall, and I'm with the Louisiana Baptist Office of Public Policy. And first of all, I want to make it clear that I oppose bestiality, and I'd like to add my admiration for Senator Morrell for the extra effort he's making to add protections for God's creatures, because I think that's commendable. In fact, I think it's needed. But I agree with Representative Hodges, and I agree with Reverend Mills in this regard. We have a law which is working. We know that people are being arrested and jailed for bestiality, this crime against nature. And the only objection I have to what Senator Morrell is doing is removing those 4 words. And so I appeal to you to retain that and add the protections that Senator Morrell is proposing, and I think we'll have the best of both worlds.
Reverend Husser.
Thank you. I concur with my colleagues at the table that the problem with this is that in line 11, where they're stating the current statute, is that they are removing these 4 words. I applaud Representative Hodges in her effort with the currently failed amendment that needs to stay in there. Obviously, every one of us in this room by now, after this discussion, we all need a prescription for some form of anti-nausea medicine. But however, I thank you for dealing with this, but it is tricky wording when we remove 4 simple words. Our challenge with which we are for stiffening any penalties against anyone who would ever commit a crime against nature. We're for that. But however, it's tricky because when the laws are written here, sometimes the interpretation in the courts can be different than the original intent. And that's where we caution you on this, to leave these 4 words in there. And thank you very much. I concur with my colleagues at this table.
Thank you, Jim. And I'm not making predictions, but I know Reverend Mills quite well, and the other 2 gentlemen as well. Y'all will, if it does get out, y'all continue to work with the author and try to get it in a posture where everyone can be okay. Yes, sir. Okay, thank you very much. We got the author back to the table. Also filling out cards in support is Raphael DeCastro, Louisiana Foundation Against Sexual Assault, Brandy Melissa from Baton Rouge, Julia Bro, the Humane Society of the United States, Jennifer Ansardi representing Jefferson Parish, Morgan Lamadre, Sexual Trauma Awareness and Response, Michelle Hall, Louisiana SPCA, Jean Menard of Church Point, Louisiana, Hilton Cole of East Baton Rouge, Animal Control, Bud Corson, Jim Nickel, Louisiana Veterinary Medical Association, Charmaine Cassiopa, NOLA, Beth Brewster, Companion Animal Alliance, Sean Cassidy, Louisiana Foundation Against Sexual Assault, and Eric Sustrom, Humane Society of the United States. There are no more lights.
Can I close real quickly?
Absolutely.
I'll be extremely brief. I appreciate everything Mr. Mill said. I think I've tried to work with all parties on the bill. I think when you try to compare our crime against nature statute with other states, you're really comparing apples and oranges. And I say that because our crime against nature statute is problematic because it's in violation of Lawrence versus Texas. Because of the Lawrence versus Texas decision, all sodomy laws in the United States were deemed to be unconstitutional. Part of the reason, not the only reason, but part of the reason why we're moving the bestiality statute to its own statute is because when you're making a constitutional argument, you're really making the reverse argument. This bestiality law, as it currently is stated, is in an unconstitutional statute. So we already have a Supreme Court decision on the books saying Lawrence versus Texas that you cannot have sodomy laws on the books. Bestiality is literally tied to the sodomy law, which is unconstitutional. Now, mind you, I've made the commitment to Mr. Mills and other people, though, and Ms. Marcel and I are on the same page. Like, I am for equality and gay rights and the like, and I have filed bills to do that, but those are separate bills. And I'm not saying I'm not going to file more of those bills. I will file them, but I am removing bestiality from the unconstitutional statute and giving it its own statute. So if you have a constitutional concern, your constitutional concern should be with the existing law. To my earlier point, other states that have crime against nature statutes don't have sodomy in it. That's why they were able to amend their bestiality law within their crimes against nature statute, because there were no constitutional questions with it. Ours is unique in that our sodomy law is still in the books, is still in the crime against nature statute, and that is part of the reason, not the only reason, because obviously you saw the new bestiality law is much more expansive and it's much more specific. To Ms. Hodges' points and Mr. Mills' points regarding the vagueness, this law is as vague as our current child molestation law. All the definitions, all the terminology mirrors child molestation. So if you think child molestation is unnecessarily vague and the law is not going to be stand up to scrutiny, I would argue that all the child molestation law in the books has been ruled to be pretty specific. And like I said, if I will happily amend this bill, I'll work with Mr. Stefanski to make sure that people are allowed to be around food. Got it. That I will take care of it. But if someone who is convicted of this crime, who is serving probation, wants to work in a food processing facility, I would argue he probably shouldn't be working there, because there's some challenges, at least during that probation period. Obviously, we amended the bill, Mr. Stefanski's help, to say that, listen, there's a time period after you've proven to be free and clear of this kind of problem where you can go work anywhere you want to work. It's not forever. It's just a period after your adjudication's done. So with that, I appreciate this committee's time and effort.
Representative Marcel has made a motion to report SB 236 favorable as amended. Is there any objection? With being no objection, SB 236 is reported favorable to the floor as amended.
Thank you.